All right, welcome to the Borderlines podcast. It is Friday, January 30, 2026. We're doing an audio only episode this week. It was supposed to be episode 200, but we missed a few weeks, so this is episode 198. The old crew back together. Peter Edelman, Justice Edelman, welcome back. It's been 2 years, I guess, since your last appearance.
Yeah, something like that.
Something like that.
Wow. It took us 2 years to do the 100 episodes and then...
One a week.
Wow.
With it missing a few.
I guess
The thing that was memorable, I was reminiscing, was when we recorded that, it was in Peter's old office, and some judges swung by to congratulate Deanna and I because they thought we had been appointed to the bench. And I initially thought, like, whoa, they're all excited to see a podcast being recorded. But it was very funny.
Well, times have changed. You've been elevated to the Court of Appeal since.
I have.
Yeah.
Yeah.
How's that transition?
It's been good. It's actually a very I've been finding the work to be very challenging and interesting. It's a very good. It's a good group of people. It's nice to be working collaboratively again, because
Right, of course.
as a trial judge, you're working by yourself. You're making. I mean, it's very collegial, but in the end, you're making the decisions yourself.
Right.
While here, most of the time, we're making decisions in groups of three, and so it's, which is, I've been enjoying that aspect of it, and a lot of my work when I was counsel was appeal work as well, so it feels familiar. It's so yeah, it's been.
Is that like, it almost seems, because by that point you're a more senior judge, that it's almost the inverse of what you think it'd be. Like when you start, you would be in a team to like make sure everyone's just learning the ropes. But it's, well, what was it like then, I guess, the transition from lawyer to judge versus judge to Court of Appeal?
I mean, from the transition from lawyer to judge was definitely a much steeper learning curve. It was much more challenging in the sense that you're learning a very different way of writing, a different, you have to learn not only all of the administrative stuff that goes along with, especially if you're moving out of private practice into, a government institution, that there are a number of adjustments that go along with that in terms of understanding how the administration works, in terms of understanding that aspect. It's a very different job, but plus you're learning all of the areas of law in the Supreme Court. So I went from a practice that was very specialized in criminal and immigration law to dealing with everything from class actions to family disputes to personal injury. So there's a wide range of things that, and so that was a very steep learning curve. The transition to the Court of Appeal is a learning curve in a different way in terms of understanding how to work with other people. So you've got two colleagues that you're coordinating with in the courtroom, as well as in terms of the decision making.
Right.
But so there's that aspect of the learning. The other thing that I've found in terms of the writing that has been very different is that on the trial court, most of the time, in most cases, you're writing your decision for the losing party. You're explaining to the losing party why they're losing, and they're the primary audience for, in whatever case it is that you're. In a lot of my cases, there wasn't a lot of interest outside of that. In some cases, there would be broader interest for different reasons, depending on the case I was dealing with, but that wasn't the case for most of my. Well, in the Court of Appeal, I find myself having to write for a lot more audiences at the same time. So a lot of our cases, you're writing for the lower court, you're writing for the tribunal if it's a judicial review. There may be public interest or other stakeholders that have an interest in what we're doing. There's broader audiences than just the parties in front of us or just the losing party. Because in the trial court, for the most part, the winning party isn't too concerned about why they won. It'll be, while in the Court of Appeal, explaining and there may be implications beyond, and in many of our cases, that is, even things that I would have thought would be relatively easy or trivial, and we see that with some of the more the less meritorious appeals that you see from certain parties, in particular a certain subset of self-represented litigants that will make arguments that just no lawyer would make. But at the Court of Appeal, you find yourself having to explain why you can't do that, or why that doesn't make sense, but it'll be the case, like I wrote a case, for example, on default judgment in circumstances where someone was seeking default judgment where there was no reason, and no lawyer would have tried to do it in the way that this person did. But of course, there's no jurisprudence, nobody's written about it before.
Yeah.
And this will be the leading case on this issue in default judgment probably for the next 20 or 30 years.
Right.
And so you find what should be a relatively, well, in the trial court, and what happened in the trial court in this case was the judge just said, no, go away, without much reasoning, because there's no reason to explain in detail why these things happen. So that's been a challenge. It's a different challenge in terms of the number of audiences that you have.
To what extent does it matter, not who the lawyer is, but how good the lawyer is, how good their writing is? So the reason I ask is, I went out for lunch with someone from the Department of Justice a few months ago now, and they were saying, one of the things that I assume, Stephen, that must be frustrating about the private bar is that in the judicial review context, the decision on its own, sometimes it's obvious if it was reasonable or unreasonable, and it doesn't matter if the lawyer knows how to write. It doesn't matter if the lawyer knows how to argue because we're going to settle. And so the actual knowledge of the representative in a lot of cases doesn't seem to matter. Do you agree with that sentiment? Or does a lawyer's writing style matter? Or does the case often just speak for itself?
It depends on the case. I mean, some cases are where the caliber of counsel can make a difference, or does make a difference, is in terms of the framing of a case, in terms of how a case is presented. It's not like, especially when you're dealing with a more complicated record, it's not like and it's simply from a fairness perspective, we're not going to go through the record and come up with arguments that the other side hasn't been put on notice are going to be made. And so if the argument hasn't been made, and we see that in some cases where there may well have been an argument that could have been made, but it hasn't been made for different, because the counsel, for whatever reason, sometimes there may be good strategic reasons why, or there may be instructions from the client not to make a certain argument, and those are things that we don't really look behind. But there are cases where the errors are just so obvious, or that it's just that it wouldn't matter what counsel you had, the appeal has so little merit that it just wouldn't. So it's not like counsel can make a case that has no merit into a case that has merit.
Yeah.
But it can make a difference in a certain subset of cases, in terms of how the case is presented, mainly in terms of framing. I find is the big difference that the caliber of counsel will, the focus and the framing, seeing the forest for the trees.
Yeah.
Not inserting your own, relying only on the arguments that counsel makes, rather than, say, granting or dismissing an appeal for some novel area that, you notice from the facts of the case on itself. Is that something that is, consistent across judges? Is that your approach? Because on occasion you'll see, at least in federal court and immigration, a judge say something along the lines of, I'm surprised no one raised this, but blah, 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 blah. I
guess it depends on the case, and it depends on what it is that a judge is doing as to whether a judge has an obligation to be dealing. There are certain circumstances where, as a judge, I have an obligation to even if a party doesn't raise something. So, for example, in a criminal trial, if there's a criminal trial and there's evidence that's being presented that's inadmissible, or there's I have an obligation as a trial judge to step in and not allow that evidence in, even if there's not an objection from defense counsel or from in depending on the circumstances, right? So it's not like the judges don't have an obligation to present things. And in some cases, there may be a decisive issue where you would raise the issue and give the parties the opportunity to respond. So it's more a question of procedural fairness. But if there was a decisive issue that engaged the best interest of a child that I saw on a case, I would be likely to raise the issue with counsel or with the parties to give them the opportunity to respond, as opposed to saying, well, my decision may not be in the best interest of this child, but but nobody raised the issue, so I'm not going to do anything about it. In other circumstances, I might, if I have two sophisticated corporate parties in a complex bankruptcy situation, there can be all kinds of reasons why issues get raised or don't get raised, and so wading in and saying, well, why didn't you raise this issue, can be rather fraught in those circumstances, and so I might be less inclined in those types of circumstances to be raising new issues, as opposed to deciding the issues that have been presented by the parties that are in front of me.
Yeah. I think that the thing that you're saying about what happens in federal court with things getting settled is that I do think it's somewhat unfortunate in federal court that some issues that are ongoing problems never see the light of day in the courtroom because they do get settled. But I think that that's a different question than the question of whether or not the quality of the argument and the quality of counsel can add to the likelihood that a matter is going to be successful. Because I think sometimes there is, as Justice Edelman was saying, is that there's a way, I think, of framing it and showing the implications of what a certain precedent is going to, like, how is that going to impact the jurisprudence in general, that sometimes has to be put forward in a way to say, like, well, if this is how you're going to decide this, then this is going to be the consequences on subsequent cases. And
well, I think there is a bit of a debate, though, like at least in the immigration bar, amongst some people, like I think you recently spoke at something, I'm not going to name names, where another lawyer was presenting saying, well, judicial review can largely be cut and paste.
Yeah.
And there's this, and I think the bench has started to comment on how certain counsel are engaging in cut and paste.
Yeah.
And kind of as you said, where there's all the stuff that doesn't actually make it to a hearing because the department settles.
Yeah.
There's just this interesting issue from the private practice, because neither of us copy paste.
No,
but
and you have
it's
to keep
becoming an
evolving.
increasing
Yeah.
topic.
Yeah.
Yeah.
It's some of the limitations of judicial review, whereas you have more, fewer limitations in terms of what the jurisdiction is that you have to, like, actually get into the legal issues in front of you.
It depends on the case. I mean, it depends on the area of law, and it depends on the cases. But we see, you will see, whether it's in the trial courts or elsewhere, you'll see certain counsel or not unrepresented litigants who will be cutting and pasting materials that, it's in some cases, you even have materials where it's like they haven't even taken the names out from the precedent that they were using. That's right, from the previous, or you have just entire sections that aren't relevant to the case in front of you that's clearly been cut and pasted from something else.
Do you see an appeal as well, or is that more at the lower court?
Usually in the lower court, at the Court of Appeal, there generally will be the counsel who appear in the Court of Appeal as a group. The one subset of litigants that we see more in the Court of Appeal, or that are a bigger part of our work, are what I'll, not necessarily the people who are more litigious, and a subset of whom would be who engage in vexatious litigation. They represent a relatively small number of people for example, in the Supreme Court. They might be less than 1% of the litigants in the Supreme Court, but because they appeal everything, they then end up, and only 5% of people appeal. If they're 1% and 5% of people appeal, and they appeal everything, they end up making 10 or 20% of our work.
Right.
And
of
so
course, there's no leave requirement, and so there's no way of vetting the cases that come up to.
Or even if there is a leave requirement,
because sometimes there is, I imagine.
There's a leave requirement, but then there'll be an application to vary the decision of the judge who denied leave, and then there's a whole it can create a volume of appeals and further engagement with the court. Right. In terms of a small subset of litigants who are who use a significant number of resources, both in the lower courts and for different reasons. I mean, some there are different motivations in terms of what's going on there.
There will always be people that try and weaponize the law to, like, as an instrument to combat another party. This is just an ongoing issue, and it exists no matter what.
Not all of them. That's not always the dynamic. So sometimes it's somebody. When someone's weaponizing the law as in terms of that their target is the other litigant. Sometimes there's some type of mental health issue. It's either an obsession with a particular outcome or a particular result. Sometimes there's a delusion about, and all of the conduct would be reasonable if the conspiracy was real.
Right.
In other words, there's a conspiracy, and this is what's happening in the conspiracy, and you need to do something about it.
Right.
And but there's all of the conduct is not unreasonable.
Right.
If the conspiracy was real. And from the court's perspective, there are circumstances, and I saw that in my practice as well, where I had claimants come into my office with stories. I remember one in particular where it was, I think, some 36 pages in all caps.
Right.
An absolutely very difficult to believe story. Yeah. That the more we looked into it, the more it turned out to be true. Mm-hmm. Because sometimes they are out to get you, even if you're not from a country that was. It wasn't.
Didn't you have one where, like, a government injected someone with hepatitis?
No, I don't remember that one.
No, maybe I'm.
Yeah, sometimes the truth is stranger than fiction.
Sometimes the
especially
truth is.
Especially in the immigration field and refugee. Yeah.
Oh, this is one where that CBSA, after we had reframed things not in all caps, that CBSA didn't even intervene in the case because everything checked out. There was all it was something where there was plenty of information online about this person's case, but they were from a non-refugee producing, not a normal refugee producing country.
Yeah, no, checking your assumptions is definitely something that, like, totally. I think in all areas people constantly have to do.
Yeah.
You mentioned before when it came to decision writing that you're often at the, I don't know, lower court or Supreme Court, whatever word you, and for those who aren't in BC, the Supreme Court in BC is like the lower
entry
court.
Level.
It's kind of the opposite of, I think, most other places. But you mentioned that at that level you're writing essentially for the losing party to explain why they lost. At the Court of Appeal you're writing for different audiences. To what extent do you write and review each sentence to be like, what are all the different ways that this can be interpreted? So, like, we had Justice Mosley on whenever we're probably a couple years ago now, a year or two ago now, whenever he had just retired, and we'd asked him about the Lee decision, which we've talked about ad nauseum on the podcast, but it's a espionage case in which some people were interpreting one sentence that now retired Chief Justice Crampton wrote as like possibly meaning that all Chinese people could be inadmissible to Canada for espionage, which probably wasn't what he meant to say. But you could read the sentence and be like, I see how people could get there. So I guess actually there's two parts to this question. To what extent, when you're writing your decision, do you look at it as like, what are the different ways that this sentence can be interpreted? And is it almost even possible if you're writing on your own to like know the different ways? And do you think there should be a mechanism to simply correct, or if everyone is like loading in on a sentence, right now the decision's written, it's final, that's it, you can appeal it. Should there be an ability, if say the media or a party or something is saying, what does this sentence mean, for the judge to be able to clarify it? So two parts.
Two parts. I mean, so the first question is in particular at the Court of Appeal, and that's part of the reason for having three people together, and it makes for much better decision. We spend a lot of time going through the decision, and a lot of the time we agree on the results. We spend a lot of time disagreeing about the wording,
Right.
And sometimes it's part of it is a question of coming to a consensus on what the meaning should be.
Right.
And sometimes it's about coming on a consensus.
How does it work? Do you sit in a room like this, the three judges, or is it by email? Is it?
Well, so what will generally happen is we'll identify a first writer for a case. The first writer will send a draft around, and then we send drafts back and forth with track changes and often very detailed changes. Sometimes there's no changes at all, and sometimes there's very detailed comments on certain sections that it's Is
it all in writing, or do you just meet in a room sometimes and hash it out?
Sometimes we get together in a room, and if it's something that needs to be worked out in terms of the results, or a big issue needs to be worked out, then we'll arrange a meeting and sit down and talk. We generally have a meeting before the appeal, and we'll have a meeting after the appeal, where we talk about the direction, like the appeal that we did today, for example. Before I came here, we sat down for half an hour. We talked about the direction that it's going to go in. The first writer is going to go away and write a draft, and we'll get the draft, maybe in 2 weeks, maybe it'll take a month. It depends on the workload. When we get the draft, and then it'll be a question of go through it, and then do I agree with the results? There's the first question, but we all have a sense of what the result will be, or at least that's where we're at right now. And sometimes what happens is the first writer goes away, tries to write it, and is like, the result doesn't write.
Right.
As I've gone through the case, I'm not getting to the results so I'm getting to a different result, and this is why we need to get together and talk.
Right.
Or here's my draft, I came to a different result. Here's why, and then the other two will then need to consider their positions as to whether or not it's a situation where you're like, look, we just disagree.
Yeah.
And so in some cases it's just clear. Look, we agree to disagree.
Yeah.
I'm going to write a dissent, or I'm going to write a concurring opinion. And so we have a case like where you write a concurring opinion or you write a dissent, you agree to disagree, and it is what it is, and there may or may not be feedback. That depends on the court and depends on the individuals, but generally speaking, there won't be a lot of feedback on if you're dissenting, you're not getting a lot of feedback on the
How many rounds
opinions.
does it go? So at least with Supreme Court decisions, which I read more than BC Court of Appeal decisions just because I don't appear before the BC Court of Appeal. Not that I've appeared before the Supreme Court, but they're more relevant, at least for immigration in some areas. Like, you'll see the majority reference the dissent, which references the majority. Like, how many times does it go around before they're like, okay, guys, this is it. Like, we're publishing this.
Oh, I mean, it'll depend on the case, and it's helpful. In the end, it's a question of what's going to make a better decision. In other words, is it going to make a better decision, or are you at the point where this isn't going to be helpful? But having a majority decision that doesn't consider the dissent may not be helpful to the audiences, and especially at the Supreme Court of Canada, where they have even more audiences than we do, right?
Yeah.
In the sense that they're writing for a much broader audience, and it may actually be helpful to those audiences for the majority to clearly say, we agree with that, we don't agree with this, in terms of what the dissent has done, because ultimately the majority is the law. And it may well be that the majority agrees with some part of what the dissent has said, right? Or that they don't disagree with it, and so that those clarifications can be helpful in some cases. And so it's more a question of what is the role that this decision is playing. If it's really just a question of a disagreement on a discrete issue that's not making law, then it probably doesn't matter what I think of the way that you wrote your view on it, right? If we're writing something that's going to have an impact in a particular area, then the wording may be, and in some cases, what will happen is that we'll come to an agreement. We can't come to an agreement on exactly how the law is going to be framed at this point, but it doesn't matter in this case. So it can be framed in a more generalized way. And so it doesn't need to be, it can be more vague at this stage.
Because you can decide on the narrower issue?
And well, you go as far as you need to be able to decide the issue that's in front of you, and leave to another day a more refined articulation of the law. And so that's kind of how the law will evolve. While in some cases there's just a consensus that this can be articulated very clearly and precisely, there's only one way that this is going, and you're not concerned about the implications. But in some areas of the law, there may be concerns about, okay, well, what are the broader implications?
Yeah.
What are the broader? How is this going to play out in cases different than the one that's in front of us? And in some cases, you're not. I can't think of all the different permutations, and so you keep it. You try and keep it more restrained.
And then that second part about correcting, like if how it is to write, knowing that you can't clarify or defend how you may have worded or what you may have meant by because often you'll see one sentence in a 50-page judgment can just become the focal point of lawyers, contention, the media. How do you think that judges should be able to address their decisions, or no? You're shaking your head.
I'm shaking my. I think that it's a question of what your role is and when your role is complete, and that's the and there's a good reason for saying that giving a decision is a discrete act that you are empowered. You're given a role to make a decision and to explain what the decision is that you've made. But if it was going to be an ongoing role to defend the decision, you've given your reasons. You give the reasons that you made that decision in the moment, and the reasons that you're satisfied with that explain that decision. And in terms of defending the decision, there may be stakeholders or parties or other people whose role it is to defend the decision afterwards. But your reasons speak for themselves. The concern around having judges give further commentary afterwards is what is the status of that commentary? Is that part of the decision? Is it not part of the decision?
Right.
It's something you thought about later.
Yeah.
It's something that you, and we'll see this even in cases where you'll have judges give oral decisions.
Right.
And our court has commented on this before, where a judge will give oral reasons, and then when a transcript is requested, they get significantly amplified. And they're not the reasons that were given to the parties.
Have you seen a decision that you wrote? I mean, I guess it hasn't been that long yet, but one of the questions, going back to what I had asked Mosley, was Justice Mosley, was that I was on some federal court AI task force, and Justice Mosley was on it, and there was a DOJ lawyer on it. And and the DOJ lawyer said, well, we have to remember the principle from this case. And Justice Mosley said, well, I wrote that case, and yes, those are the words that I said, but I think you have to like view it, in the circumstances of then, and this were sort of, he kind of elaborated on it. And it wasn't in a public forum, it wasn't in, it was just in this internal federal court task force. But it just made me wonder, like, have you had judgments that you've written get interpreted in subsequent judgments where you think, that's not fully what I meant?
Well, and ultimately, it's not for me to decide. It's not about what I meant. It's about what I said. Mm-hmm. And ultimately, that's where it's important to be careful. Mm. But it also provides a certain amount of flexibility in the law. That interpretive exercise later on is also an important limitation on the power of the judge in a common law system, that you have evolving jurisprudence and that it is going to be interpreted.
Yeah.
And so the consensus building in this that's built into the system isn't just about the three judges who make the decision. It'll be about the next three judges who interpret that decision, and then the next three judges who interpret that decision, that are going to reinforce the direction or shape the direction of the law. It's not like the person who wrote the original decision has some type of different, and they don't have a role later on in interpreting. You have a role in saying, in speaking as a judge, and in your decision, and you give your reasons, and then the interpretation of the reasons. And it may well be that you're called on to interpret your own reasons, but you don't have one of my own cases was cited to me today, that where it's like you said this. And
I do that whenever I can.
And I may well
I always try to look up what has this judge said before.
And I may well find that persuasive. Mm-hmm. Or I may not find it persuasive, right? In other words, that in terms
you go, I wrote that? Really? I wrote that?
Consistent with other judgments that you've made, like they should be able to tally. Yeah.
And it may be that in the I mean, this decision isn't particularly controversial in the case that we were dealing with today, but it may be that the other two judges that I'm sitting with think that the case that I wrote says something else. And that would be the law. Mm-hmm. Their interpretation of what I said would be, even if I write a dissent about what I meant, what they say I meant is what the law would be.
Yeah.
Oh, right? So, and so, because it's not what I meant, it's what I said.
Yeah.
And
I have it's a very out there question, but I sort of like gently push it into the room, because I've been thinking a lot lately about it's one of the basic underpinnings of our entire justice system, which is that justice comes out of adversarial proceedings. And so for some reason, I've been kind of questioning this in general. And I don't know, I wonder sometimes whether or not this whole idea of two people coming at a problem from opposite extremes and then having somebody adjudicate to decide where is the rightness from those two perspectives. I don't know, I'm just kind of curious whether or not, I guess whether either of you think that there is call to kind of re-examine whether or not that's the best way to come up with the appropriate decision.
For a justice system or for dispute resolution broader?
I guess that's maybe the right question. But I think truly for dispute resolution, but even in terms of adjudication, I guess because you're going at decisions with a group of three, it's sort of more like consensus building. But yeah, we've all taken for granted that this is how the system is to work, rather than in a more discursive kind of a way, where, I don't know, put it out there for what it's worth.
I mean, I think for me, it depends on what it is what types of decisions you're talking about,
Mm-hmm.
and what types of resolutions of disputes. I mean, there are a lot of mechanisms in family law, for example,
Mm-hmm.
for mediation, for alternative dispute resolution, for other ways of managing. And in fact, litigation is a very, and generally speaking, and not to speak of any case in particular, but as a general, parents who get to the point of a trial in Supreme Court
Mm-hmm.
have a profoundly dysfunctional co-parenting relationship,
For sure.
right? I mean, it's not something that is,
Mhm.
and it may be that that's the result of one or the other or both, but to get to the point of a trial, there are a number of mechanisms that would have been bypassed
Yeah.
that are almost invariably in the child's best interest, that don't involve an adversarial
For
process,
sure.
because an adversarial process to manage a co-parenting relationship is profoundly dysfunctional.
Yeah.
And a co-parenting relationship goes on for a long time.
Mhm.
Like they're not the types of disputes that are resolved and then it's over.
Yeah.
It's the type of, it's a relationship that if you've got a 5-year-old child, you're still going to be having discussions of who's paying for university 20 years later.
Yeah, for sure.
And so it's not, and then, who gets to go to the wedding and all, like, it's not something that goes away
No,
at a
for
certain
sure.
point.
But even in our own practices as lawyers, I think we've all been in situations where you can tell palpably that the lawyer on the other side doesn't actually think that their argument has merit, but it's just kind of part of the ritual of going through the litigation process.
Well, or they're getting instructions from a
Yeah.
client.
Sure.
But I mean, even
That
with the
and I mean a lot of the cases that I've seen in the immigration realm. I mean, a lot of the colleagues that I had in the immigration realm never litigated.
Mm-hmm.
They would resolve everything through internal mechanisms, whether it's at CIC or at the visa post or whatever. There are a number of ways of engaging with a bureaucracy that don't involve litigation.
Mm-hmm.
even litigation, a lot of the time, I almost don't view it as adversarial, the judicial review process, because a lot of it is you've started with a bulk processing software making a decision, and that initial judicial review, a lot of the times, this goes back to what I was saying earlier about the decision standing on its own or not, is getting a set of human eyes on it as much. Like I almost don't view, like, for a huge subset of the judicial reviews, I don't even view it as adversarial so much as the federal court. It's too bad that this has become its role almost, is
I know.
the opportunity to get a set of human eyes on just to review something. I can give an example that I think you'd appreciate, Peter, is that just to give a sense of how the quality of decision making is going, is we had a case, and I talked about it once briefly on the podcast, and people wrote to me to ask if it was real, including ghosts of CBSA, which telling you about ghosts of CBSA is a whole other topic that we can get into. But we did a visitor, so someone was in Canada and we were trying to extend their status so that they could attend an admissibility hearing that the government had scheduled. And in the purpose of visit, in the application form, the purpose of visit was attend government scheduled admissibility hearing. The way the refusal generating software works is they will have the line, I am satisfied that the client has had ample time to attend purpose of, and then it will copy paste what's in the field. So the thing literally said, and DOJ settled, because that was the federal court here was just to say, like, look, this clearly, it wasn't, I didn't view it as adversarial. But the thing literally said that the client has had ample opportunity to complete the purpose of attending the admissibility hearings scheduled by the government. I mean, we had another one, I'm sure you've seen them too, where it says someone will put in the form, please see attached, and the refusal letter will say, the client has had ample time to attend the purpose of please see attached. And that the judicial review process, I don't even view that as like adversarial as much as, excuse me, can we get a human?
Yeah,
That's
exactly.
basically the role of the federal court now is, excuse me, can we get a human?
I mean, this is clearly where this is coming from, is my frustration with the judicial review process. And it's not really even the fault of the court, it's just that the backlog has made that process so dysfunctional. Not just the backlog, but the quality of the decision making in the first instance. But it's not just that, it's also about the thing that I've been insinuating about the capacity for the legal process to be weaponized, and just also the, like when you're reading about cases involving like acts of violence, the way that the victims are sort of the way that kind of adversarial process and having to be a witness in these things, and how that's so punishing for the person who has been assaulted, for example. Like, these are just the types of things that I'm thinking about that I just, even though we understand, because like in the federal court, you can win, settle, whatever, your judicial review, have it sent back after a year and a half and all these expenses, and then have another refusal, and that merry-go-round that we're seeing repeatedly. So yeah, I guess that's what.
But I think, I mean, like, if IRCC doesn't want to settle, their lawyers shouldn't settle. Like, I don't know, I view that as like, that's the lawyer's job is to advocate on behalf of IRCC. Why IRCC in some cases chooses not to settle might be questionable, but like, I don't see a system where the lawyer would be able to settle on behalf of a client who doesn't want to settle.
For sure.
Especially because there it definitely, it definitely on redetermination won't have a favorable outcome.
But this is what I'm saying, though, is that it kind of perpetuates that that problem, like it facilitates these adversarial proceedings going on, even, if it can be, like, it's pretty clear, it's pretty patent that there's no merit in the decision.
I think for like one of the things I've definitely seen in terms of the work that I've done over the last few years in terms of working in a bunch of different areas of law is the different dynamics that there are. Just in my own practice was always with government on the other side. And the dynamics of conflict are very different in that context than they are when there's interpersonal conflict.
Right, of course.
And interpersonal conflict where you'll have litigation proceeding that makes no sense on the face of it.
Right.
People spending $20,000 to fight over $5,000.
Right, exactly.
Right, where
because of anger.
because it's personal.
Right.
Right, because it's about something other than the results on the face of what they're seeking.
Right.
And a lot of my engagement with government was also, a lot of the work that I did was trying to figure out what are the public policy issues that the Crown is dealing with? What are the priorities? What are the concerns that the Crown has? And how can those be addressed in a way that doesn't result in my client's deportation? Right? And so it would be a question of getting my client into counseling, getting my client to do pay restitution or do whatever to actually resolve or address the harm that's been done, or to address the public policy concerns, whether it's in terms of retribution, whether it's in terms of that, and that's really a question of the Crown that you're dealing with, about the overall, whether it's the federal Crown, whether it's the provincial Crown, whether the nature of the offense and what the dynamics are in a particular situation. And we see a lot of creative ways of dealing with criminal offenses, or creative, alternative or different ways of dealing with criminal offenses than the adversarial trial process. And in fact, it's always been the case that the vast majority of as long as I've been in practicing in criminal law, that the vast majority of criminal cases are resolved by way of, whether it's by way of plea bargain or by way of some other arrangement with the Crown, where the Crown doesn't proceed with the charges.
Yeah.
And then in terms of different models for mental health courts, for Indigenous sentencing courts, for different, and it really depends on the circumstances that drug courts are another example where you see the underlying issues being addressed. In family law, you have a number of other dynamics that come up, whether it's in child protection, whether it's in dispute resolution. The dynamics are very different in those areas, and some of the areas that are that actually don't lend themselves. I've been surprised at some of the areas where you see that I just didn't expect. The people in those areas aren't surprised by it. But for example, estate litigation.
I was going to say, when I was at BLG, it was estates for me. I was always surprised
that there wasn't more alternative dispute resolution. Is that what you mean?
That people would spend their whole inheritance on legal fees, fighting over how to divide it, and it would all go to legal fees.
Yeah.
Well, one of the cases that went up to the Court of Appeal, before I was on the Court of Appeal, but went all the way up to the Court of Appeal, and I don't know how much, the primary issues in the case was a ring that was made out of a bolt by the dad that had been given to the mom, and who was going to get this bolt ring. It was like a bolt that was like a bolt that had been made into a ring, like a bolt that had significant sentimental value, but obviously because the litigation went all the way up to the Court of Appeal, around who was going to get this bolt ring, right? And it's but there's a lot more emotional engagement, and so different. The dynamics are very different and different. I find in different areas of the law, it's been an interesting perspective for me in terms of seeing, and different. Like for example, we dealt with a lot of cases around best interest of the child when I was in immigration practice, but from an immigration perspective, not to simplify what we did, but it's usually relatively straightforward. It's not in the best interest of the child for dad to be deported or mom to be deported, right? Or it's not in the best interest of the child to be sent back to Somalia or whatever the situation was, right? Whereas in family law, the question of what's in the best interest of a child gets very complicated, especially when you're trying to make those decisions for our own children around COVID restrictions, for example. And I was appointed as a judge just before the COVID pandemic, and a lot of the issues that came up in the family law cases were around all of the questions that we all had as parents around. Should they be in a bubble? Should they be should they be wearing masks? Who gets vaccines when? And all of the questions that we were struggling with as parents, people in dysfunctional co-parenting relationships were relying on judges to make those decisions, right? And so in those cases, you find a very different level of conflict and engagement. But there you're engaging with the best interest of the child in a very different and in a much more concrete day-to-day manner than we were in the immigration context. And I found that it's been quite...
So just looking at the time, I want to ask the question, because I thought it was about 20 minutes of talking, but we're at 50 minutes. I want to start with the question, or not end necessarily, because I know you might have a few more questions, but the question that I said I would lead with, and we'll now get to 50 minutes in, is it easier to judge or be judged?
I mean, it's got different. I guess I'll answer it in this way in terms of is it easier in my role as a judge or in my role as counsel? and to be judged, my role was as counsel. So in terms of being the subject of the decisions, I was representing the people who were subjected to the decisions. But my role as counsel in some ways was more challenging, and in other ways was easier. And it was one of the things that I realized. I had realized it when I used to do testimony before the committee. You've both done testimony before the parliamentary committees. And so, when you do the first few times, you do it on behalf of the CBA. You go in and you have the policy document, you have your position, and then you give your presentation. And this is the CBA's position. This is what the and then if they ask a question that's not there, you're like, the CBA doesn't have a position on that, right? But when you go in, and I'm sure you've both been as an individual.
I've actually only been as an individual.
Okay, so the first time, so for me, the first time I went as an individual, it was, so I show up and then I'm like, oh, I don't have a policy. I actually have to come up with, what is my position on deportation, or what is my position on, what are my views on these things? Well, as an advocate, it's relatively straightforward. I'm going to make this argument. My client shouldn't go to jail, or my client should go to, and it's actually a relatively straightforward way to write and to think, because I have a client, my client doesn't want to get deported. Whether he should be deported or not is not a decision that I'm making. Whether he's going to jail or not is not a decision I'm making. And in some cases, I actually found one of the hardest decisions, which I thought would be one of the easiest things to do as a judge, when I was a trial judge, when I first became a trial judge. And as criminal counsel, I had done joint submissions dozens and dozens of times. It's a very common thing to do. You come to an agreement with the Crown, you go in front of the judge, you say, we agree, here's the sentence we've agreed on, here's why. And the jurisprudence is very clear that judges are not to, are generally will go along with those unless so there's some very strict criteria around going outside of a joint submission, and for reasons that are set out for those who are interested in a case called Anthony Cook. But the first time I had to do it, and there were two senior counsel who I knew, very respected counsel. It was a very reasonable sentence, given the context. And it was even in a situation where if I hadn't done it, the Court of Appeal would have done it.
Are you talking about going outside of the joint recommendation?
No, if I had gone outside the joint recommendation, the Court of Appeal would have overturned me and imposed the joint recommendation. It was clearly within the lines. It was reasonable. It was within the law. It was a very difficult decision to make, because I had to send this 20-year-old guy to jail for 2 years, or I forget what the amount, for a long period of time. And his mom was there in the courtroom, and there were other people there, and it was surprisingly difficult.
Right.
It wasn't an easy thing to do, even though the decision wasn't difficult. So making the decision was from a legal perspective. The answer was obvious. There was only and so in that sense, and in the context of what the sentence he would have faced after trial, this made all kinds of sense. I would have done this as his defense counsel, right? So it wasn't a decision that.
Was it difficult because you were? I mean, it still falls within the question of, because you had to read it out loud. I guess you would have had to read it out loud.
Well, I'm the one who had to send him to jail.
Yeah.
Right. I mean, I'm the one who had to send this guy. I made that decision. I'm the one who. And when I talk to some of my other colleagues, they, and their view is, and if that goes away, you should retire. Right? If that feeling goes away, and that you don't understand the weight of what you're doing, then that does. And so they are, making the decision is different than advocating for the decision, right? And so that aspect I did. There are other parts that are a lot easier, in the sense of I'm not up until, like I heard an appeal today based on my experience in preparing for appeals, right? The counsel who argued the appeal in front of us today are exhausted in a way that I'm not exhausted. Because they've been preparing that case for the last 2 days. Possibly were up late yesterday. So in that sense, there's aspects of it that are easier.
Does that impact like being a judge the way that you make decisions outside of being a judge? Like, does it? Or do you try to approach everything where you're like you want to consider both sides? Do you do the Trump thing where whatever the last sentence you heard is what you repeat? Like,
I mean, does it affect what I do outside? I don't. That's a good question. My kids probably think so. They're.
And you're married to a judge, so I was going to say.
I'm married to a judge. There's no. But in the end, you're having to make those decisions with the kids anyways. I don't know that my mom approaches it differently than I do. Like, I think I probably approach it more like my mom would than like a judge would. But
that's perhaps why you had the predisposition to go this course in the first place.
Exactly. Is that to a certain extent that's the approach that, like my mom had 5 kids and there was, but it would be the same thing for the two of you as parents. It's their decision. You're doing decision making, and if the kids.
Although they would say, like, one thing that they would say, and that my wife would say, is that maybe it has nothing to do with being a lawyer, but like you start specific words, you'd be like, well, what do you mean by like what? It depends on what you mean by this. And she'll often say, well, you're so lawyerly in terms of like wanting things defined.
She's a lawyer too, isn't she?
No, she's not a lawyer. She's government. But is there a judge equivalent?
Well, I don't know. I think my kids have picked up even when they were. I remember my son. He was probably two or three or two, something like that, where he was like, first, I'm right. I'm right.
Yeah.
Second, you're wrong.
Yeah.
Right? It's not.
When I was young, people always said that I was a lawyer, and I was like, what are you talking about? I don't know, because I was like, whoa. And now I see it in my daughter, 100%. She's like, when she argues, she's got this whole argument put together. It's all like she litigates in every argument. And so I think we do have these predispositions, and there's kind of like, it is kind of like a calling, and it might even annoy.
I thought you said cult.
No, it was a bit of a cult. And there are different ways of doing it. Like, I used to always talk to Dennis McRae when I was working as his associate, and he had a very different approach where he never got super angsty about his cases. He would figure it out, he would approach it as a problem, he would structure his argument, but he didn't wear the outcome the way that I do. Like I would, and this is still something that this is my biggest struggle as a lawyer, is like not wearing the outcome the way that you're saying about like, I mean, again, to me, that's just inherent to being an advocate, that I really empathize with what they're trying to go through. I want to get this outcome for them, and when I am not able to, I feel that sense of, and so I very carefully select the cases I work on, all this sort of thing. But I like the approach that he had. I always have been a little bit envious that I could get to that place where I'm like, I've done what I could do, and then let the chips fall and trust in the system.
It's a tough balance.
Yeah,
right?
for sure.
It's not a. I mean, for like it's in particular in refugee law, I found it to be a very tough balance of you have to be engaged enough that you care, but you can't be so overly engaged that you haven't slept the night before the hearing and that you're completely dysfunctional as counsel.
Yeah.
and that so you have to find that role where I was able to help people.
But I
the
like
most
what your
effectively.
colleague said to you, that like the moment you stop feeling that, then you should retire or resign. I do think that I think that the idea of trying to do justice is an important component of it. Like, we have ideas about what the outcome should be, and that kind of principled approach.
I think for me, that'd be the hardest part actually of being a judge, would be even like that weight that you're talking about, because I feel like I'd hear a set of arguments and I'd feel like, oh, that makes sense. And then the other side would make their arguments, oh, that makes sense too. And then I would look at the paper and go, oh, shit. Now what am I? And I feel like I would like sit there and be like, oh, actually making the decision, at least to me, because I go back and forth on so many issues that I feel like, especially at like a court of appeal level or a higher court level, where you're making like, and I guess even some of the like, say Aboriginal title or other cases where you're making these sweeping things. Like, I feel like I would sit there and just be like, the clock's ticking. I got to make a decision and go back and forth. Like, well, how do you resolve that? I'm sure you've had files where you're like, you go back and forth. You can't do that forever.
I mean, I don't remember if you remember when we had we had Justice Rothstein on the podcast a few years ago.
Almost a decade ago.
Yeah.
Almost a decade ago. That and one of the things that he had said, which I now understand more, was that he said that when he was on the trial court, at the federal court, but on the trial court, he was like, most of my cases were easy cases. In other words, it was the answers were obvious in the majority of the cases that I had. And then when he got to the Court of Appeal, there were more of them that were difficult, but most of them were not. And then when you get to the Supreme Court of Canada, then the easy cases are the cases where the as of right appeals from a criminal matter, and there a judge on a court of appeal felt strongly enough about the other side to write a dissent, knowing it would go to the Supreme Court, and those are their easy cases. And I think I have found that in terms of in the trial court, most of the time the answer's pretty obvious by the end of the hearing, in the sense that there weren't that many difficult cases in terms of knowing what the result would be, and the stakes aren't the same in all cases either. And in some cases, it's also a question of having a certain, and this was true when I was counsel as well. Is that it's a question? It was a question for me of also checking my self-importance at times as well, as to how much of a difference, how much am I actually going to take on the fact that I'm the one who's going to change the world, right? That I'm going to change all of these, that I'm going to take on that extra case, or I'm going to take on that. And it's like, well, it's not because I stay until 10 o'clock at night that, and in some cases I do, but it's a question of that type of balance. What I find in terms of the cases that are more difficult, and that was a question of also just learning to write, and you start writing it, and sometimes it just doesn't write, and sometimes you sit with it and you try and figure it out, and sometimes a decision just has to be made, just like it does in life.
So is that your approach when you're stuck, to just start typing and see if that process helps guide your decision?
Well, you try writing one side or the other, right, and see how the decision feels, right? That and that was one of the tricks that I learned as a kid as well. I forget who taught me this, but basically that you flip a coin and see what your initial reaction is to the results.
Yeah.
And you flip a coin, and then you're like, oh, I'm disappointed. Oh, then maybe I'll go get a burger. Then maybe I'll go get a burger or whatever. They go on for a trivial decision, right? Yeah. That you're disappointed in the result. It's because you wanted the other result, right?
Yeah, exactly. It's like a gut check, like you do have some instinctual reaction, and that means something.
Yeah, and so as you're right, and that's why reasons are important in those cases. That sometimes I haven't had a lot. I've had like once or twice, like like 2 or 3 times when I've started writing, and you're writing on an issue, and you're like this just doesn't.
I'm not convincing myself.
I'm not convinced. This isn't. It doesn't work. It doesn't write.
Yeah.
And so then you write the other way.
Yeah.
Or sometimes what I've had is I've just had a clerk, in one case, I just had a clerk write up a memo for me about why I was wrong. Tell me why I'm wrong, right? You wrote up a memo, and you read the memo, and you're like, well, okay.
Yeah.
I'm even more convinced, right? In the sense of, or vice versa, like, oh, actually, you know what?
Yeah. I mean, that's the thing, you have at your disposal the submissions of both counsel, you have your clerk who can try and help to facilitate, and that's what deliberation is.
And you have colleagues to talk to.
Right, exactly.
I mean, that's the other thing, is that a lot of the time, what'll happen is you'll just go into another judge's office, even if they're not sitting on the case with you, and the judges won't decide the cases for you.
Yeah.
I have the advantage of having 2 other judges who are deciding the case with me, and so in those circumstances, we will have very engaged discussions around, and often it'll be what will happen, because you have judges at the Court of Appeal who, because of the nature of their practice that got them to the Court of Appeal, are quite good at seeing the forest for the trees. And often one of the people on the division will be, I'll be like, this is like really complicated, I don't even know where to go. And they'll be like, well, yeah, but there's this path here. And then you'll be like, oh, there is that path.
Yeah.
That makes sense. Oh, I see how that works. Just like when I was in practice.
Yeah, for sure.
We'd
just
sit around, you talk it around, and then Steve would be like, well, why don't you do blogs? And I'd be like, oh, well, of course, right? That's an obvious solution, right?
Yeah, for sure.
And then once it crystallizes, then the work is easy, right? Or is easy. It's still work to write the decision or prepare the case,
For sure.
but once you see that path,
the answer offers itself. I mean, I certainly do that. I'll ask somebody to just be the sounding board, and as soon as you start explaining the problem and what you're trying to say and how you wish to, the answer just presents itself, as long as you have those colleagues who can provide that sounding board and offer some feedback.
Speaking of flipping coins, it's time to decide what to eat, and I think we're going to wrap. We're recording this in the evening, a little late. I don't know if you have any other final thoughts, or if not, flip a coin and figure out where we're eating.
All right, sounds good.
Awesome.
No, it's been great. Glad to have a chance to come back and chat with you guys.
Awesome. It was funny listening to numerous people reference it when you made the Court of Appeal, being like, and he has a podcast. Did you know he had a podcast?
He had a podcast.
Yeah.
So funny.
The coolest, yeah.
I don't know if people said the coolest, but
No,
yeah.
there was a lot of people calling it cool to have a podcast, so.
Although now that I've left,
Well, I know I feel like I'm cool.
It turns out you guys are much more efficient since I left, though. Because I think how long did it take to do the first 100 episodes? And then,
Honestly, if it hadn't been for the pandemic, it probably wouldn't have been work. Once we figured out Zoom and then StreamYard, we remember for the back in the day when we had mics.
Oh, yeah.
I don't know why we had mics now. Maybe phones are better now. But anyway, let's eat.